Ádám is a Hungarian jurist from Budapest and the legal officer at the Hungarian Civil Liberties Union, working in the privacy project. That is, at its aim is to safeguard the rights of individuals in the face of unnecessary governmental interference. So we are kind of swiftly transitioning from Laura's and Anastasia's talk into how we can actually help with oversight when the government is or other state actors are on the other side. So yes, Ádám's work is in data protection, processing the illegal data processing by government, combating illegal secret surveillance by the state, and he's also creating the framework regarding digital rights strategy, AI litigation against big tech, etc. So hello, Ádám, welcome, and thank you for being here and talking to us. If you would like to share any screens, you are free to do so.
Hello, and thank you for the introduction. Yes, my talk will be about democratic oversight over national security services, as it is set out in the case law of the European Court of Human Rights. One of the important aspects is that this does not necessarily mean that someone who had been subjected to illegal secret surveillance will actually get any kind of redress for these actions, but they can go before the European Court of Human Rights, or the Strasbourg Court, as we also often call it, and try and have their cases heard and technically present that the legislation in their home country does not provide for adequate safeguards against secret surveillance in such a manner that amounts to a violation of the European Convention on Human Rights. And I think that I will start my presentation here because this is basically where it begins. If I will be able to play the slides. Oh, yeah, okay. If you can see it.
Yes, great.
Okay, thanks. So, as I've already mentioned, there's a legal background for all of these. Well, I hope that I won't go into too much legal detail because I just want to give a brief overview of what national security legislation looks like according to the Strasbourg Court. So its basis is Article 8, protecting privacy of the European Convention on Human Rights. And it should be noted that this is an institution of the Council of Europe, and it's not a European Union body, because national security affairs do not fall under the competences of the European Union. So this is a completely different thing. The Strasbourg Court, or the European Court of Human Rights, was established in the European Convention on Human Rights, and it is a separate thing from the European Union. I only show you Article 8, the right to respect for private and family life, because there are certain important words or technical terms that we have to pay attention to, namely what amounts to an interference with a right, what it means to be in accordance with the law, what is necessity in a democratic society, and of course also what national security can entail. I would like to go into a little bit more detail about this. As we have seen, national security is one of the legitimate aims of interference, according to the European Convention on Human Rights. This is because even when we have fundamental rights, this does not mean that these rights are unlimited. They can be interfered with, but this interference has to be proportionate. It has to follow a legitimate aim, and it has to be necessary in a democratic society according to the convention. As we have seen, national security is one of these legitimate aims. So rights, the right to privacy, can actually be curbed in the name of national security if this follows the proper legal standards. What we know about the term itself, national security, is that it's relatively vague. There is no comprehensive definition, and it is technically up to the state to decide what it considers a national security interest or a national security threat. The Strasbourg court accepts this because it will essentially put the emphasis on how safeguards work and not on these technical terms, because it can actually be accepted that national security threats cannot be easily categorized. They can come in many ways. They can change with time. So essentially, this field itself necessitates some sort of vagueness in what terms we use. Also, because of this, of course, its substance is not easy to grasp, but the European Court of Human Rights has given some substance to this word or this definition. For example, the security of the state, the functioning of basic democratic institutions, etc. Also, the court has accepted that when a state invokes national security, this has to have a reasonable basis, in fact. This also touches on the problem of national security threats being sort of vague, but it only means that the state has to justify, it has to reason why it regards some phenomenon as a national security threat. It's not enough from a state to simply say or evoke national security without any limits. The status of victims of the violations of these rights is an interesting one in the case of national security, because by default, nobody will ever know if they had been secretly surveilled by the state. These surveillances are secret by definition. They are secretive. The people concerned will never really have any hard evidence that they had been subjected to this infringement of their rights. But the court reacted that it would make Article 8 of the convention hollow. It would hollow it out if the court demanded evidence of being victimized in cases where it is essentially impossible to prove this. So instead, the court chose that anyone can claim to be a victim of secret surveillance if the scope of national security legislation is vague enough, if it's not clearly defined who can be subjected to secret surveillance, and if there are no domestic remedies available, that is, there is no oversight over the national security services that persons concerned could turn to find redress for their grievances. So essentially, what the court looks at when someone claims to be a victim of surveillance is not whether they had actually been subjected to surveillance, but instead whether if they had been, they could find any effective remedy, or if they could find out whether they had been abused this way, and whether they could address this before the independent institutions of a given country. Since this is not the case in every country of the Council of Europe, it can easily be said that some legislations or jurisdictions do not provide adequate safeguards simply because they don't have the necessary institutions to guarantee the freedoms of persons living in those jurisdictions, which is, of course, a broad interpretation of victimhood, but it is essential in such cases. I listed just 2 cases here. The first one is a German case where this principle was laid down. And the second one is a quite recent Hungarian case where it was reiterated again, and which found Hungary to be in violation of Article 8. As we take a look at these technical terms, it's important to find out or to know what it means for an interference to be in accordance with the law. Because we have seen that interferences can be justified, they can be legal, but they have to abide certain criteria. And one of these is that they have to be in accordance with the law. This means 3 things. The first of which is that the interference must have a basis in domestic law. It must be written down somewhere in domestic law. And the second one is its quality. It means that it has to be accessible in principle and in practice to persons concerned. So let's say acts of parliament, pieces of legislature have to be accessible to the population. They have to be able to at least have a look at these acts. And another aspect of quality is foreseeability, which technically only means that persons have to foresee the competences of national security services and government bodies in ordering secret surveillance and what they can expect from such surveillance, and what these government institutions or bodies would act like in such a case. So this is a quite formal requirement which concerns the quality of the law, but there was also another requirement, a necessity in a democratic society, which will mean the proportionality of the measures of that national security services can take. These criteria were established in the Roman Zaharov versus Russia case, and we can see that there is some overlap with the previous access to law and accordance with the law requirement. As we can see, accessibility is listed here. It means the same thing that I have mentioned before. We can see that all of these requirements pertain to the procedures of secret surveillance. They function as checks and balances against unlimited government power or power on the side of the secret services. They work to balance the power imbalance that is between an individual and services that that technically have the technology and the legitimacy or the legal capacity to carry out the most invasive forms of the invasion of privacy, which can be, of course, secret surveillance. What is important is that the scope of application of secret surveillance measures cannot be unlimited. There has to be some basis in law regarding which situations could give rise to such surveillance. The duration is important so that they cannot go on infinitely or indefinitely. Data protection is also an important aspect. Again, that data collected on individuals cannot be stored for an indefinite period of time. Also, we shall see later that the authorization and supervision and the notification of persons concerned are very important aspects of the review of the surveillance, because these will decide whether these secret acts, this surveillance, will be carried out proportionately and according to the law, and not illegally. So this brings with it the question of the review of surveillance. Which has 3 stages. Of course, before surveillance is ordered, or when it is ordered, when it is being carried out, and after it has terminated. According to the European Court of Human Rights, what the most important aspect of these safeguards is that they have to be carried out by independent bodies. The effectiveness of the control will depend on how independent the bodies supervising national security services are. In the end, it concludes that eventually it is the judiciary that can be said to be the most independent of government bodies, but it does not regard it as a violation if there is no judicial control, because it can be compensated for either by other safeguards or by other bodies that have sufficient independence, and which in such a case are kind of similar to the judiciary. So when a surveillance is ordered, it is the best solution probably to have a judicial oversight over such an ordering of surveillance, but this is not going to be necessary according to the court if there is a possibility of judicial oversight after the termination of secret surveillance. So when the surveillance is being carried out, it is not exactly elaborated in the case law of the court, what kind of institutions it would, or bodies it would accept as adequate safeguards against abuses of power on the secret services side. But what we know is that it should be an independent body. here as well, of course, which carries out the control, because otherwise, of course, it cannot be expected from national security services to follow the rules, follow the law, if they are not overseen by an independent control mechanism. And of course, after the surveillance has terminated, I have already mentioned that this is another possibility for judicial oversight, but it is not entirely clear what we mean by this. So do the courts have a right to initiate investigations themselves, for example, or should it be a person subjected to surveillance who can initiate a legal procedure before the courts? As we know, the second one is not very likely, because nobody will know about secret surveillance being carried out regarding them or their person. And the first solution is just not what the judiciary normally works like. So judges don't normally initiate random procedures. And this is why the court ruled that it is a necessary part of safeguards against illegal surveillance that the institution of subsequent notification exists. This means that persons subjected to surveillance must be notified after the surveillance has terminated and at a time when this notification does not endanger national security anymore, because of course we know that if someone is immediately notified of having been surveilled, that could go against legitimate national security interests. But there is a time for every surveillance when it just becomes unnecessary to retain this information from the person concerned any longer. So this is why the court ruled that indeed, since cognizance of being subjected to surveillance is a precondition for victims to be able to demand judicial remedy, their notification is a necessary element of any democratic legislation of national security surveillance and services. Yes, so essentially, this is the only necessary institution according to the court, and there is the optional judicial oversight, which either has to be at the beginning, at the ordering of surveillance, or it has to be made possible after the surveillance has ended. We could also criticize the court's decision because, of course, once the violation of a right has happened, legal redress is not the same as judicial oversight before the ordering of surveillance, when the breach of a right can still be prohibited. So it is a bit questionable whether these two can be equivalent or not, but this is the case law of the European Court of Human Rights. So I would try and say a few words of the Pegasus case in Hungary, and then see whether Hungarian oversight mechanisms work according to the prescriptions of the courts. In Hungary, we've had about 300 phone numbers included in that list of 50,000 that had been leaked to investigative journalists. We do not know whether these 300 people were all surveilled or not, but their numbers were indeed in the database, and we know of some people who had actually been surveilled, who had found the Pegasus software or the remnants of the software on their phones. These include journalists, business persons, politicians, and even surprisingly members of the intelligence community, both from the governing party and from the prior government, which is now in opposition. We are monitoring these cases at the Hungarian Civil Liberties Union, and well, we would like to represent clients, but it is not yet certain whether we will. It is certainly what we would like to do. And well, what would this surveillance look like when it is ordered according to the Hungarian laws? Would it stand up to the test of the Strasbourg court? Well, not really. The Szabó and Vichy decision that I have mentioned earlier, the case brought against Hungary and illegal surveillance in Hungary, shows that the safeguards are completely inadequate presently in Hungary to prevent unlawful secret surveillance. And unfortunately, since that decision in 2016, nothing has changed. So it is not even really on the government's agenda to change this situation, which breaches almost everyone's rights, as we have seen, because we can all technically claim to be victims. Well, the rules of secret surveillance are set out in the National Security Act, which only represents a part of all secret surveillance that can be carried out by Hungarian authorities. It only concerns the national security services, but there are other authorities like the police, the prosecutor's office, etc., that can carry out secret surveillance. But only national security services can carry it out for reasons of national security, which is interesting because other authorities do not have the same unlimited scope of applying secret surveillance as national security services do. This means that if they claim that national security requires that someone be subjected to surveillance, it will technically be always legal because the terms are sufficiently vague, but this is not the main problem. The problem is the application of these terms. Technically, anyone can be surveilled with a ministerial approval of surveillance, and we can easily see that a minister is not an independent body. It's not like the judiciary. It is, in fact, often in the government's interest to spy on dissidents, on political opponents, etc. So a ministerial approval cannot bring any independent oversight. It is also a problem that subsequent notification does not exist in Hungarian law. So nobody will ever gain cognizance of having been secretly surveilled. They have no way to find any remedy for such a situation. And since this is the case, since oversight is not independent, it means that technically all surveillance will be legal because the Minister of Justice, who approves this surveillance, will always approve them, and this will technically make them legal on very vague grounds. There are also issues with judges. Sometimes there are judges who are involved in ordering national security surveillance. But the problem is that, as we know, not a single judge has ever denied a request for secret surveillance in Hungary, probably because they are in a very, very close relationship. There are special judges who can issue such approvals, and they are in a close relationship with national security officers. They also need a security clearance in order to be such a judge. And this national security clearance can be only issued to them after national security services have vetted them. So they have these judges who decide on whether surveillance is legal or not are precisely the ones who are who have been subjected to such surveillance, and whose private lives are perfectly known before the security services, which of course makes them less independent, or even impossible for them to deny requests for secret surveillance. And I think that this is the end of my presentation.
Thank you, Adam. And it actually reflects back to some of the previous talks we had during the day. Like, for example, there was one ethical hacker talking just before you, she is saying that it's really difficult to protect yourself from state surveillance, exactly because the scope and the resources are like much larger than, for example, in possibly criminal networks. And we have a question there that, are there ways, in your view, for individuals to protect themselves against cyber surveillance? And what even are the forms nowadays that are used for cyber surveillance?
Excuse me, where can I find this question?
It's in the chat.
Because I think that there are several questions.
Yeah.
So how much it is an individual versus communal problem?
We can skip that for now, and then,
okay.
The following one was
okay.
how
Thanks.
individuals can.
Okay, so, well, for example, the Pegasus case shows that that is one way of how cyber surveillance can operate. Phones can be hacked. As far as I know, the Pegasus software and some others that are similar to it are very sophisticated. They don't even need, you don't even have to click on a suspicious link or anything in order to get your phone infected with these programs. That's why I think they call them zero-click programs. But technically, it is possible to surveil someone's internet connection. It is very easy to collect metadata. It doesn't even need. It doesn't even count in Hungary as secret surveillance. As far as I know, and it can also happen because of state's proneness to data retention. There was a regulation of the European Union which prescribed that states had to collect the metadata of communications in bulk and store them for at least 6 months, if I remember correctly. And all member states installed such regimens until this regulation was quashed by the Court of Justice of the European Union, which technically makes such data gathering illegal, but nevertheless, many countries still have these databases. For example, Hungary does, but I also know of Ireland, which has such a database. Unfortunately, I have no real idea how someone could protect themselves against such sophisticated methods of cyber surveillance as the one that Pegasus presents. As far as I know, most programming engineers do not know a good solution for this problem either. But if you do know one, someone in the room, please feel free to share it.
So is it more the oversight that we can trust, and making sure that is
yes,
actually strong enough and it works?
Exactly. I think that is the main question. I think that it is okay, essentially, for governments to have such really effective and powerful tools that they can use for national security. The problem arises when there are no safeguards against government abuses. So unfortunately, if there are no safeguards, if there are no legal guarantees and the institutional guarantees against the infringement of your rights, then the government is not even going to need any sophisticated software, because they can simply bug your home or listen to your telephone conversations, open your mail, etc. Whereas if there are adequate safeguards, if the legal system works well, even the most invasive technologies, I think, can be employed without a substantial threat to individual rights. But of course, this opinion can be contested.
Esko, do you want to jump and ask your question? And I think we will finish there after that.
Okay, yeah, thank you. So one of the themes we're looking at is the erosion of public institutions. And so the nature of my question is, in Hungary, you have public institutions that are being used, and I don't comment on like whether they're strong or weak or what have you, but you have those and you use them in order to defend from excesses of government. In other places, there are governments who typically had quite strong public institutions that are being eroded, and it's actually the government of the day's idea. Just last week in the UK, they tried to tear up the parliamentary standards rulebook. That's the latest story. So my question really is, do you have any evidence that other countries who are trending towards illiberalism are actually learning from the Hungarian experience of how you can, how the states can overreach a little bit? And I guess the flip of that is, do you have other civil liberties unions who are contacting you and saying, hey, we have this new problem that maybe you have experience with, and can you help us? Like, our public institutions are being eroded. I don't know if you can comment on that.
So you mean international cooperation or NGOs in Hungary?
Yeah, international cooperation. So, like good and bad, like foreign governments trying to, can I say it, adopting the Orban playbook, maybe.
Yeah.
And then other civil liberties unions saying, like, how have you been defending against that with your institutions? We're losing ours.
Yes, we are in several cooperatives with international organizations and NGOs. But essentially, I think that our country's problems can be so diverse that it is not easy to give a substantial substantial help or advice to anyone living in different countries. For example, we are members of INCLO, which is a meta organization of international human rights NGOs. But our members come from such different places like Ireland, Hungary, India, Israel, and Palestine. These places have very diverse issues. Some of our other some of the other institutions that we are a part of have as diverse members as I don't know, for example, Zimbabwe or the Philippines, Hungary, Germany, Israel. These countries have technically very little in common regarding the problems that they are facing. So I would say that it's rather international communication, and for example, the other kind of help, like drafting amicus curiae, which literally means friend of the court, and it is just an opinion letter technically, by someone who is not party to a case, but who would like to send their opinion anyway to a certain court. For example, the Strasbourg court allows this. And then if there is a case that one of our sister organizations brings before the Strasbourg court, then other organizations can write such amicuses, as they are called. We can also communicate together. We can make or write reports together. So there is a wide range of activities that we can do, but I think that essentially, even with our help or each other's help, the case in every country is so specific that it's the NGO working there that has to come up with the solutions. We can help somewhat, but I think that not necessarily in the most substantial sense. I don't know if this was an answer to your question.
Yeah. I think so. Thank you very much, Ádám, for joining us today and giving us an insight into how these kind of things and legal background to the surveillance and how it works and what we can do and where we should focus our attention when we want to work on the democratic side of oversight. So
thank you very much for having me.